Court program. It's with great pride that I welcome you all to the 15th annual Moot Court competition. Before we begin, I wish to offer a few words of introduction and acknowledge those who have made this possible. Our Moot Court competition was founded over a decade ago by our very supportive alumni and friends of the college, and that includes Dan Cotter, class of '88, Brad Narstadt, class of '89, and his wife, Debbie Narstadt. They were soon joined by another of our alumni, Kate Cross, class of '08. Together, these four individuals have supported our Moot Court competition, both financially and through volunteering to serve as judges of the preliminary round of oral arguments in the competition, as well as the judges for our legal brief writing competition. Without them, the program would not be responsible. We're also grateful for our judges who will be presiding over the case today. Serving as our Chief Justice in that role this evening is Associate Judge Greg Bader. He is of the 9th Judicial Circuit Court of Illinois, and we are very thankful that he has decided to join us this evening. Accompanying him in the role of justices, we have our colleagues, Professor of Business and Economics and Director of the New School of Business, Mike Connell, and Professor of Theater, Vanessa Campagna. All of us are indebted to a number of individuals who help ensure that this program runs smoothly. While I'm unable to name everyone, I definitely have to thank Marnie Steach, the Executive Director of Career Readiness Advising and Student Services, for many years of hard work in helping to build this program and figuring out all of the logistical support behind this, making sure we have chairs and tables and wonderful food provided as well. Speaking of the food, we have to thank Aramark for that as well. I hear the spinach artichoke dip is good. Also, I would like to thank our Communications and Marketing Office for providing a live stream and coverage of today's event. I would also like to thank the American Moot Court Association. This is the first year we've used one of their cases. You will hear their case today. They've generously given us permission to use this for our own competition. They run a national competition this year with the exact same case that we're using ourselves. Our case today is William Denolf versus Olympus State University. The case itself this year is actually completely fictional. There is no real William Denolf, and we are supposed to imagine that there is a state in the United States of America called Olympus and an Olympus State University. However, I believe we can easily see the potential for similar situations arising in the real world. In our case, the plaintiff, William Denolf, is both an aspiring student and a university lecturer. While a lecturer, he decides to apply to a different school at his university, but is denied, and he claims it's because the admissions policy favors women. This brings in the 14th Amendment and its mechanisms for providing equal protection under the law. Meanwhile, while he's teaching in this other program at the same school, he starts complaining about this admissions decision to his students, and then in all sorts of public fora. This brings in, of course, the First Amendment. Denolf lost the case in both the district court and the appeals level. Our setting is intended to represent the Supreme Court of the United States of America, his final chance for appeal. While the situation is fictional, all of the law and the case law our students will discuss are based on real court cases. And I think this touches on a number of important issues that we can see happening today, challenges to providing equal protection under the law for many categories of Americans, and challenges regarding our freedom of expression. The academic setting, of course, is also one that I think we can all relate to. This past Saturday, 14 students gathered to participate in 2 rounds of hearings. Our judges, Dan Cotter, Kate Cross, and Brad and Debbie Narstadt, selected these 4 individuals who are beside me to be the top 4 advocates and compete in this final round. They emerged out of a very competitive group, and we should celebrate the great work of all of our participants, including a few that are in the room. So let's just give an early hand of applause to everyone who participated in this. It should also be noted that some of these petitioners had to learn new questions and positions just in the short time since the competition on Saturday. Representing the petitioner, William Denolf, are Andrew Himsel and Emily Leshen. They will go first and have the opportunity to reserve time for rebuttal at the end. Representing the respondent, Olympus State University, are Nora Collins and Calvin Wellman. Each student will have a total of 10 minutes to speak, though that might vary slightly based on the judge's questioning. During the competition tonight, we ask that you hold your applause until the end of all the competition. If you have not already done so, please silence any phones or electronic devices as well. Now on to the case. We are now in the Supreme Court of the United States of America. Please rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of the United States, oyez, oyez, oyez. All persons having business before the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Be seated. Good evening. This is the case of William Denolf, petitioner, versus Olympus State University. Will counsel for petitioners please introduce themselves?
I'm Andrew Himsel, petitioner 1.
My name is Emily Leshin, I'm petitioner 2.
Counsel for Olympus State, please introduce themselves.
My name is Nora Collins, and I am the respondent 1.
My name is Calvin Wellman, and I am respondent 2.
We're here for oral argument in front of the Supreme Court, and counsel for petitioner, you may proceed.
Thank you, Your Honor. May it please the court, my name is Andrew Himsel, and I represent William Denolf, the first petitioner on this appeal. At this time, I would like to reserve 1 minute for rebuttal. Your Honors, the facts of this case are that my client, Denolf's 14th Amendment rights were violated on the basis that sex was a sole factor for his denial into the Kelley School of Law. This policy of OSU is inherently suspect and violates both strict scrutiny and intermediate scrutiny, proving to be unconstitutional. Your Honors, in this case, strict scrutiny is applicable, as I will demonstrate through Frontier v. Richardson. This policy is not narrowly tailored with the least restrictive means and provides no compelling governmental interest, thus failing strict scrutiny. This policy, even if applied to intermediate scrutiny, fails, as it provides little to no governmental interest with means that are not substantially related to the goal of the school. Denolf was denied due to his gender. As testimony recounts by admissions officers, had Denolf been female, he would have been accepted. OSU's policy proves unconstitutional under strict scrutiny, failing to utilize the least restrictive means of a narrowly tailored policy to reach compelling interest. Strict scrutiny in this case is applicable as it is in cases of gender discrimination, as shown by Frontier v. Richardson. Strict scrutiny applies in this case as OSU's policy discriminated solely on the basis of sex.
Counsel, isn't it under United States versus Virginia, test intermediate scrutiny? Doesn't the Supreme Court say that already?
Intermediate scrutiny was later favored, but this case shows in my application that strict scrutiny can be held to cases of gender discrimination. This policy is not nearly tailored with the least restrictive means and fails to achieve a compelling interest. Gruder v. Bollinger's use of nearly tailored to a compelling interest shows that this policy of OSU fails. It does not provide an individual, holistic review and does not use the least restrictive means. Denolf had all the soft variables and qualifications required by the school. He held a master's, 2 bachelors, 5 years as a state trooper, ranked in the top 10% of his law class, top 20% of his undergraduate class, and scored nearly 10 points higher on average on the GRE than the average candidate. Had Denolf been female, as provided by testimony, he would have been accepted, proving he did meet all the soft variables and requirements of the school. OSU's policy was not narrowly tailored. They denied half of all the female applicants. OSU's policy is proved to be unconstitutional and not nearly tailored with the least restrictive means and does not provide an individual holistic view. For a policy to be unconstitutional, Gruder holds that to be nearly tailored, these policies and standards must be met to abide by strict scrutiny, which OSU fails to do.
Counsel, the purpose of equal protection is to protect the minority from the tyranny of the majority. And we want to protect African Americans, we want to protect certain religions. Do you think the Constitution is written to protect white males?
Maybe rephrase that.
Why does he need special protection from this court, from the equal protection?
Well, because this
Why does he deserve this?
Your Honor, because this policy inherently overlooks the specific qualifications of a candidate relying on sex, an inchangeable factor for the basis of admission rather than one's changeable qualifications. Thus, it would be applicable.
So counsel, do you think it's just a numbers analysis then? There's no soft variables involved?
No, there is definitely soft variables involved, but in this case, Denolf met all the soft variables, which is proven in testimony by the school, stating that had he been female, he would have been accepted, proving that as a sole basis.
Is that based on his scores or based on the soft variables?
It's based on a variety of things, both in culmination. But overall, his denial was based on the sole factor of his sex.
I would also like to interject. You mentioned, quote, he would have been accepted, end quote. In my review of the case, there were only 2 members of the admissions committee that indicated that. Were they speaking with the authority of the full committee? Were they empowered to do so, or were those their subjective opinions as only 2 witnesses?
No, they were administration officers. They were testifying for the school under oath.
Thank you for clarifying.
Thank you, Your Honor.
But he was also above the scores for many people that were accepted, right? So we don't know if there were soft variables involved in that testimony at all. He had the scores, had he been a female, he had the scores that would have qualified him regardless.
Correct, but they overlook all of the individual factors such as his scores and the soft variables. He was a state trooper for 5 years and met other soft variable factors that would otherwise have led him to be accepted if he were to be a female, but because he wasn't, he was denied. And in this case, unlike Reuter, testimony shows a lack of holistic reviews. OSU's policy does not meet a compelling governmental interest and can meet its goal of increased female enrollment in other ways. Increased recruitment budget, targeting female students for missions, policy waivers, workshops, tickets, all are ways the school has implemented to increase female enrollment at the time that they denied Denolf. OSU states necessity for diversity and increase females in law, but this can be done through the methods stated. No evidence is shown that preferential weight towards female applicants will improve female enrollment, as female enrollment already had peaked in 2010, reaching the school's goal without these policies.
But it was declining after that, right? Isn't that why they implemented the policies? Because the female enrollment was declining? So they had the policy put in place so that they could attract more female applicants. Isn't that the situation?
No, there was a variety of other methods that the school had started to employ at the time that they denied Denolf, so there's no real evidence that these methods wouldn't necessarily help. This case more so shows that Denolf's sole factor for denial was on his sex. And furthermore, this 2010 data shows that the school without these policies was capable of meeting their standards, but they themselves had allowed it to decline and only now seek to rectify their harms by discriminating against Denolf for unchangeable factors.
And what's the purpose of having the policy at all? If they were already meeting already had a significant number of female applicants, why institute the policy at all?
Correct. This policy, in fact, works against Denolf and other male applicants as it discriminates on the basis of gender rather than qualifications shown here. Denolf did meet all the requirements, but because he wasn't a female, he was denied, discriminated against his 14th Amendment rights. This policy shows to be, even under intermediate scrutiny, this policy is unconstitutional. Kirchberg Fenstra held that gender preferences or assumptions violates the Equal Protection Clause under the 14th Amendment, and under this, OSU fails intermediate scrutiny. As the OSU policies of OSU relies on overarching gender as a basis for treatment or equality. Kirchberg shows that policy violates my client's rights as it means are not substantially related to an important interest, thus violating his rights even under intermediate scrutiny. The means are not substantially related to a goal of increasing female enrollment, as such could have been done through non-discriminative means. The school has increased the recruitment budget by 20%, had increased scholarships, mentorships, and outreach at the time of denying Denolf. There's no significant evidence that this policy enacted by the school, which discriminates against males, would have done any more good than these current employed methods.
Where's your evidence, please?
These are stated in the case of what the school had been doing in testimony.
I would challenge your reading on that respectfully. I believe that the point is that the school was trying other avenues first and were not achieving their results, so the policy was then implemented. Am I incorrect on my reading?
Yes, Your Honor, respectfully. Because these policies cut off in 2020, there's no significant evidence that showed that there was necessity for these policies to be implemented. while the data shows that females are declining, this was policies enacted by the school that caused a decline of females, and there was other means to improve such. The data is not reflective of the entire situation. Furthermore, the policies do not meet an important interest. OSU was not the only top school to produce leaders in law. Denolf was denied in favor of female applicants with weaker credentials. Denolf's testimony by the admissions officer shows that the sole basis for Denolf's denial was that of sex, not qualifications. Denolf was just as capable as a female recruit, yet the policy is an overgeneralization of inherent differences of sex, which is unconstitutional, as shown by Virginia v. United States versus Virginia.
You say there's no compelling reason here. Their argument was that the citizens and the troopers, the people underneath the supervisor, want to look up and see role models and see the community, the leaders that look like the community. And your argument is that's not a compelling interest?
Because there are other methods of doing such rather than discriminative policies in the administration level. They can do such with outreach versus other methods of increasing the recruitment budget by scholarships, mentorships, but they chose to imply or utilize discriminative means. And as outlined, both under strict scrutiny and intermediate scrutiny, OSU's policy fails, proving unconstitutional as in violation of my client's 14th Amendment rights. And to remind your honors, this case passed with a near narrow margin in the Court of Appeals. And through Frontiero, this case should be viewed through a lens of strict scrutiny. For these reasons, we respectfully ask that this court reverse the Court of Appeals decision. Thank you, your honors.
Thank you.
May it please the court, my name is Emily Leshin and I represent William Denolf, the petitioner in this case. At this time, I would like to reserve 2 minutes for a rebuttal at the end. The First Amendment to the United States Constitution demonstrates the importance of a democratic society's right to express itself without fear of government interference. For this reason, speech of political nature is the most protected under the amendment. Without freedoms for public discussion, our democratic institutions would cease to exist. This court must overturn the previous ruling of the Circuit Court in favor of the petitioner. The court's prior interpretation of the First Amendment demonstrates the importance of these 3 things: public concern, academic freedom, and speech as a means of wrongful dismissal. The plaintiff spoke as a citizen on matters of public concern and satisfied the Pickering test. The public concern Mr. Denolf brings to attention is the issue of affirmative action practices. In the case of Pickering v. Board of Education, the Supreme Court established a precedent that public employees have a right to free speech with protections under the First Amendment. The Pickering balance test demonstrates that interest as a citizen in making a public comment must be balanced against the state's interest in promoting efficiency. Additionally, Pickering demonstrates that public employees have the best position on the inner workings of their institutions to make judgments on matters of public concern. This ensures that there's transparency and accountability in government, which is essential for a healthy democracy. While there was backlash from disagreeing individuals on the statements the petitioner made, this was not his intention nor his responsibility. In the cases of Heim v. Daniels and Adam v. University of North Carolina, it is held that academia falls under a different type of understanding in regard to what the First Amendment protects using the Pickering balancing test. Upon his rejection notice, Mr. Denolf used the Freedom of Information Act to gain insight as to why he was not accepted. What he discovered led to his concern for the public's right to equal protection in an academic setting. Mr. Denolf believed that the public deserved to know the gravity with which a public institution discriminated against one sex. In a statement made by Denolf, he calls for an end to laws that favor people based on immutable characteristics. What he is referring to is affirmative action. In Adams v. University of North Carolina, it highlights 3 clarifying questions on a similar issue. Number 2 states the employee's interest in speaking upon matters of public concern outweighs the government's interest in providing effective and efficient services to the public. During Unity Fest, a student-organized community event, The plaintiff gave a beautiful and thought-provoking speech on all the ways affirmative action harms those in society with their right to equal opportunities.
It wasn't only Unity Fest though that he was making these statements. Where else was he making these statements?
That's correct, Your Honor. He also was making statements on podcasts. He went on a few morning shows. And he was making those statements after Unity Fest. A video from Unity Fest did go viral. Yes.
Although Unity Fest was held on campus, it was hosted by student government. The president of the institution encouraged the invitation for professors to speak. He was one of those professors. Was not the onus on him to clarify that he was speaking as a private citizen? Is it not implied that he was speaking in his position as a professor on that very campus?
No, Your Honor, because the Unity Fest was open to the community to make speeches as well.
So when a theater professor hosts a public performance and speaks to the audience, they are in that context speaking as a public citizen and not the theater professor?
Can you rephrase the question, please?
Sure. On a college campus,
Yeah.
when they host a public performance of a play and a theater professor gets on stage to speak to the audience, it is not implied that that person is speaking as a theater professor, but indeed as a public citizen.
I do feel that the situations are slightly different in that the community was also allowed to go on stage and make statements and speeches as well. And he was not introduced as a professor.
Nice distinctions, thank you.
You're welcome.
He was talking about himself, wasn't
His experience, yes.
he? And he was talking about it in class, right? He was talking about it at lunch with coworkers, wasn't he?
Yes, he was, Your Honor.
Okay.
He was making these statements because it was his professional opinion that there was something unjust going on, and it was not specifically just about the policy, but about affirmative action in general. And because of the situation in which he was put in, he felt that it was his civic duty to explain to the public and to people who knew him very well how the affirmative action policies could hurt others.
So people in his classroom and people at lunch are the public?
No, Your Honor. However, they are the people closest to him, and I felt that my client was just expressing his concern before he decided to speak at Unity Fest. Now, when he was speaking in a campus setting in his classroom, he was speaking to his students because it fell under what he taught. He taught a gender-specific class about gender and law, and so it related to what he was teaching his students.
Don't you make contradictory claims? You claim, on the one hand, he was a private citizen speaking on an issue of public concern. But you also claim he has academic freedom and he's exercising his academic freedom as a professor. Aren't those contradictory?
Can you rephrase for me, please?
Was he, is your main argument he was a citizen speaking out as a citizen? Or he has academic freedom as a professor to say the things to teach his students?
I believe those are interchangeable, Your Honor.
Thank you.
His speech condemned affirmative action as an entity, not OSU or the policy. To quote his original poem he delivered, "Imagine there's true equality. Imagine all the people living life equally." He felt it was his civic duty to inform the public about how affirmative action created discrimination and an uneven playing field by all those affected. It is a privilege for this community to have Mr. Denolf's advocacy on such controversial but vital issues. In accordance with academic freedoms, Deemers v. Austin shows the importance of protecting academic freedom. My opposing counsel may try to bring in an interpretation of Garcetti. However, later cases have affirmed the importance of protecting those academic freedoms. Who are we as a nation if we do not rely on and protect the educated words from individuals who dedicate themselves to the importance of knowledge? Justice Stevens commented in 2006, "The notion that there is a categorical difference between speaking as a citizen and speaking in the course of one's employment is quite wrong. It is senseless to let constitutional protection hinge on whether they fall within a job description. Protection under the Constitution should not depend on the duties of one's job. Further, it is important that regardless of employment, at the end of the day, they are just as much citizens of the United States as others who do not hold their same position." In Adams v. University of North Carolina, the decision of the Court of Appeals held that because an individual is a professor, they are employed to undertake forms of speech. This explains that the forms of speech Adams participated in do not have anything to do with his employment other than a general concept that professors will engage in acts of writing, public appearance, and service within their fields. Termination of the plaintiff's employment was an unjust form of retaliation. Looking back at Adams v. North Carolina, the third and unmentioned part of the consideration is whether the employee's speech was a substantial factor in the employer's termination decision. Mr. Denault was told he would be invited back to continue teaching. It was his understanding that he had a position for the upcoming term. When Mr. Denault was officially dismissed from his position, he received no board hearing and no alert on a teetering decision of employment. Further, the Due Process Clause of the 14th Amendment says that a state cannot take away a person's life, liberty, or property without a process of law. In interpretation of procedural due process, the government must follow specific methods before taking away one's rights. For instance, the court's interpretation suggests it would be a reasonable expectation to provide notice of a fair hearing before action is taken. Such rights were not awarded to the plaintiff. This case is one of freedoms awarded in a democratic society. As demonstrated, Mr. Denault spoke on matters of public concern while satisfying criteria based on judicial precedent. He should be allowed academic freedoms under the protections of the law and was unfairly terminated from his beloved profession as a teacher. If we allow an inch of our right to be taken away from one of our most esteemed members of society, where do we, as the United States of America, draw the line? Where do we stop and protect our most sacred way of life, of freedom? This court must overturn the previous ruling of the Circuit Court in favor of the petitioner.
Thank you. Nelson?
May it please the court, my name is Nora Collins, first counsel for the respondent, Olympus State University. Olympus State University created a policy to serve the needs of American law enforcement by increasing female enrollment. The ruling of the Court of Appeals should be upheld because OSU's admissions policy, which gives preferential weight to female applicants, does not violate the Equal Protection Clause of the 14th Amendment. I will first show that the university's decision to deny admission to William Denault to the Jackson Kelly School of Criminal Justice was not based solely on sex. Rather, the decision was based on multiple factors consistent with the Pettus Cole policy. Second, I will demonstrate that this policy is substantially related to the important, perhaps even compelling, interest of increasing the presence of women not just in the school, but in law enforcement and in the military. The court should apply the standard of intermediate scrutiny in interpreting this clause, consistent with prior precedent in cases involving classifications based on sex. In Frontiero v. Richardson, some judges argued for strict scrutiny, claiming that sex discrimination should be treated the same way as race discrimination. While some judges favored intermediate scrutiny, the court didn't formally declare that sex discrimination always gets strict scrutiny, but the case ultimately adopted the doctrine of intermediate scrutiny. At the heart of intermediate scrutiny is the requirement that a policy serves an important governmental interest. Olympus State University's admissions policy fulfills the standard by promoting the representation of women not only within the university, but across law enforcement and the military professions. In Grutter v. Bollinger, affirmative action was upheld when Barbara Grutter, a white applicant, sued the University of Michigan Law School, claiming she was rejected because the school gave an advantage to minority applicants. Michigan laws looked at grades, test scores, personal achievements, as race as one factor to build a diverse class. The Supreme Court ruled in favor of the school on the basis that diversity is a good reason for schools to consider race because race can be a factor, but it cannot be the only reason a student is admitted. Likewise, in our case, it is important that we favor women because of the skills that women hold that men may not. Just as men have skills.
Could you elaborate? What skills are that women hold but men do not?
Yes, Your Honor. Women are less likely to use lethal force and be named in complaints against the police. They are more likely to have a high level of interpersonal skills and use traits that encourage communication and de-escalation in tense situations. They are consistently viewed as trusted by their local communities and are more emotionally equipped than men in addressing violence against women and sex crimes. A diverse workplace is more productive and efficient, and our policy is clearly related to creating a more diverse workforce. A successful workforce varies in leadership, and it's good for morale. A majority of police officers report appreciating having fellow police officers from diverse backgrounds as a resource from which to draw advice as they make decisions. 73% of police officers have reported being better prepared by virtue of serving with law enforcement employees from diverse backgrounds. To increase diversity in the field, and as a school that is widely considered the best in the nation, it is our duty to make efforts to this nationwide need. No other criminal justice program offers such a high level of respect in the law enforcement community and has such a deep involvement in advancing national security. In the last quarter century, at least 25% of all police chief and commissioners came from the school. All other schools only account for more than 5%. A National Policing Institute reported that studies indicate that women in law enforcement tend to exhibit more personable characteristics and behaviors than men, as I previously stated. We have historically trained nationwide law personnel. If we are going to continue doing that successfully, we need to attract women to create a diverse law enforcement community.
Counsel, how do you interpret soft variables objectively?
Can you restate that, please?
Well, at some point with soft variables, the decision whether or not to allow somebody entrance or not allow entrance based on a soft variable becomes subjective, doesn't it?
It
How you
does.
felt about that, right? So how do you keep that objective? Otherwise, it sounds like that's a backhand way of having a quota.
We do not have a quota to meet, rather a percentage. Our goal as the admissions policy seeks to achieve and maintain a 75 to 25% male to female ratio across 5 consecutive admission cycles. As we are reviewing applicants, an individualized review considers a range of attributes that goes beyond sex, although sex is a factor. Some of these may include the life experiences, where applicants may have grown up or where they live, how many languages they speak, if they describe themselves as religious, their involvement in the community, the background of their parents, and other abilities that they may have.
So how do you check that favorably or unfavorably then?
When you are reviewing applicants and their different skills, it is important to compare based on scores and what they submit. Petitioner William Denolf, GPA and GRE was not as high as other males that were accepted, and many of the female applicants had better work experience than Denolf. Regardless of the gender that was considered, we hold our applicants to a high standard regardless of gender. We do take into consideration all of these soft factors, although gender is accounted for.
Counsel, so at the beginning, there were no women in the program. Women came to the program, we got it up to 25%, and then for some reason, this thing felt, it's so important to have women, but the women don't wanna come, and now we need this policy. Can you help me understand why the women don't wanna come to your #1 school?
Like I said, we do hold our applicants to a very high standard, and the goal to increase women in the school cannot be achieved without a plan in place. Because we started at 0, and it wasn't until 1970 that the school went from a 100 to 0% ratio to a 99 to 1% ratio, it is not the key factor or acceptance of rejection. If that was the case, we would certainly make the male to female ratio much more equivalent. For example, in 2020, the male to female ratio was still only 91 to 9%. So after the policy was put into place, the numbers are still low because we are still looking at factors beyond gender. Many women do apply, but that doesn't necessarily mean that they are going to be accepted just because they are women.
Thank you.
Our school is very unique from others in many ways. Like I said, we stand out among many. Our programs are at the forefront of developing and implementing new technologies crucial for national security and law enforcement. The school has prided itself on producing such a diverse pool without needing affirmative action programs. However, that was before there was a need for women in the fields. That being said, our school has changed course and has now produced a greater number of female officers than the national average. In Schlesinger v. Ballard, men and women in the Navy were being treated differently when it came to how long they could stay in service before being kicked out for not getting promoted. The Supreme Court ruled against Ballard because at the time, women had fewer opportunities in the Navy, so the rule essentially helped level the playing field a bit. The court said it's okay for the military to treat men and women differently because the rule was meant to fix real differences in opportunity, not just to be sexist. There, as here, the policy in question wasn't about generalizing the sexes, rather has legitimate reasons to support legitimate ways of supporting the goals of diversity in our community, in our school, and beyond.
May I interrupt you for a moment? Something that I hear you doing is conflating or comparing at least academia and the military and national security. In reading Judge Kashimura's dissenting opinion, I couldn't help but notice, quote, while such a program may be prestigious and important for law enforcement, it lacks several key characteristics that distinguish military service academies. And you're working with the evidence on these soft skills. Is the evidence substantial enough that even if we took military out of the question entirely, looking solely at institutions of higher learning, is the evidence still great enough?
Yes, Your Honor.
Okay, can you tell me just a little bit about that?
Yes. I think that the members in our school, like I said, we hold them to a very high standard, and we produce more police officers and law enforcement officers than any other school. And we have several government relations to higher organizations.
Thank you.
Because the university's policy serves an important governmental interest and is substantially related to achieving that goal, we respectfully request that this court affirm the Court of Appeals decision. Thank you.
Thank you.
May it please the court. My name is Calvin Wellman, and I am the second counsel to the respondent, Olympus State University. We ask this court to affirm the decision of the appeals court. OSU's decision not to renew Professor Denolf's contract was a lawful and necessary response to real documented harm. Our argument is threefold. Denolf's speech was driven by personal grievance, not public concern. The resulting disruption substantially outweighed the value of his speech. As a public employee, his remarks fell within his professional role, and academic freedom does not protect individuals from conduct that threatens the institution. Your Honors, under Pickering and Connick, the court asked whether the speech in question addresses a matter of public concern or arises from a personal dispute. Affirmative action is undeniably a matter of public discourse. That is a fact. Yet the record shows Mr. Denolf's comments were not rooted in public concern, but in personal grievance. From his classroom remarks following his rejection to the law school, or from rejection from the law school, to his subsequent Unity Fest speech, the timing and continuity of his statements reveal a consistent pattern of personal frustration with the policy, not an effort to engage in a broader public debate with it. This pattern mirrors what the courts found in Rankin v. Gregory and Gorham v. Sessoms. When an employee's speech comes from a workplace grievance rather than a genuine interest in informing the public, it is not protected under the First Amendment. So while the topic he chose to speak about may sound public, the purpose and context of his remarks were not. Under Connick, speech so closely tied to his personal grievances falls outside of the Constitution's protection. Even assuming, for argument's sake, that Mr. Denolf's remarks touched on a public issue, which the record does not support, Pickering still requires balancing his interest in speaking against the university's duty to function effectively as a public institution.
And here, the balance is heavily in favor of OSU. Within days of his speech, 7 of the university's largest alumni donors withdrew their support and successfully urged many others to follow. OSU projected budget cuts to athletic and recruiting programs, seeing a 20% drop in applications overall, and a 33% decline among female applicants. The decline in female applicants is particularly concerning. As you know, previously, OSU, before Unity Fest, had had several incidents against female students and students of color. This is particularly concerning and the reason why they hosted Unity Fest in the first place. Following Mr. Denolf's speech, many prospective female students may have felt that OSU was not a welcoming environment, a concern reinforced by reports that female graduate students experienced online harassment and derogatory speech, labeling them as affirmative action babies. That is not abstract, hypothetical harm. It has only hindered the university's ability to attract a diverse student body, but also, through the loss of donations that funded scholarships and programs, directly affected students' access to higher education. Under Pickering and Connick, when an employee's speech causes measurable harm to an institution, the employer is permitted, and in this case, obligated, to respond. Heim v. Daniel and Dimers v. Austin reaffirm that even academic speech falls within the balancing test when it comes to undermining an institution's stability.
Counsel, he's been harmed. He wants to express his harm and let the world know about his harm. But he's supposed to not put his own self into this, only speak in general terms and not relate his own personal experiences?
There is a difference, Your Honor. In the case that we're speaking about, it does not seem as though he added his personal context to the argument in order to bolster it and provide a personal connection to it. Instead, it appears as though his connection to it was the sole reason why he brought it up in the first place. There's a distinct difference in a police officer saying that he's a police officer, or say, oh, excuse me, that might not be the right analogy, I apologize.
But isn't these statements made by people when we get into this debate, isn't it because generally that they've had something happen to them that they feel is wrong?
Could you restate the question, Your Honor?
Well, people always bring up, the issue becomes, okay, is he speaking as a private person, is he speaking as a public concern, but something happened to them. That's why they're speaking out. So how do we distinguish that? I mean, that's always the scenario. And you're saying, well, this happened to him, so therefore it's connected. Well, isn't that always the case?
That's correct, Your Honor, but I think that in this particular case, it seems as though his speech was not, his position as somebody personally affected by the policy was not meant to add weight to how affirmative action had personally affected him. Instead, it was used solely as the basis for why it was wrong. Just because something personally affected me, that means it must be wrong.
Did this speech occur in his workplace?
Yes, Your Honor, and that's what I'd like to get into a little bit here. So, Garcetti v. Ceballos draws a clear line. When public employees speak pursuant to their official duties, that speech is not protected under the First Amendment. The academic setting does not erase that rule, it simply narrows it. Now, Dimers v. Austin and Heim v. Daniel do make exceptions for genuine teaching and scholarship, but Mr. Denolf's Unity Fest remarks were neither. This was not a classroom discussion or published research. It was a public event hosted in OSU's name where he made a point in his speech, or before giving his speech, to identify himself as a public lecturer. As my colleague brought up, it's interesting that she used the word, it was a blessing that they had him speak on this topic. Why so? What makes him different than any other lecturer or any other random person who could have come up and gave their opinion on this topic? Was it because he was a professor? I would argue yes. His position and affiliation with OSU gave his remarks credibility. When national media later invited him to speak, he was almost always introduced as a lecturer from OSU, and that title shaped how his message was perceived. The platform and attention he received became because of his position, not in spite of it. It was his role, not just his opinion, that made this speech significant. Academic freedom is a cherished part of higher learning. That is true, but it is not unlimited. It protects the institution's ability to pursue knowledge and foster debate. yet it does not shield faculty members from the consequences of speech that threaten the university's very operation. In Urofsky v. Gilmore, the Supreme Court emphasized that academic freedom belongs first and foremost to the institution, ensuring that universities can carry out their educational mission without disruption. It is a safeguard, but not a blank check, for speech that threatens the very environment that it exists to protect. Denolf's remarks fall outside of that protection. His classroom comments were not part of scholarly research or debate. They were personal complaints voiced in an academic setting, disguised as academic dialogue. And the escalation of these comments resulted in harm that was concrete. Lost donations, reduced applications, and damage to the university's ability to serve its students well. Under Urofsky and related precedent, OSU's decision was protective, not retaliatory. Academic freedom safeguards the free exchange of ideas, not the destabilization of the institution that makes such an exchange possible.
If we're trying to protect the university and protect the university's reputation, why not bring him in and say, you're crossing the line here, we would prefer. Firing leaves very little room for negotiation. There was no warning, there was no interaction. It was, oh, you've been a bad boy, you're gone.
It's very interesting, Your Honor, because that's essentially part of what my counsel brought up. My counsel brought up the due process clause, but here, the due process clause does not mean he should have been given a chance to explain himself. That's not necessarily what it means here. It simply means that state institutions have to apply the First Amendment to any state institution, and they have to protect it. However, that protection is not absolute, as we see under Pickering v. Board of Education. So it's also interesting that you use the word firing, because in this context, they actually simply did not renew his contract. They allowed him to serve the full extent of his term, and it wasn't sudden or retaliatory in nature. The day after this, the alumni pulled their donations. It wasn't like they pulled him in and they said, "You're gone, you're fired. Please don't come back."
So do you know how long that was? Was that 2 weeks? Was that 2 months?
Actually, I do not believe that the case said how long the remainder of his contract was.
I don't remember that either.
But he was allowed to serve the full amount. And the university's review followed after the consequences of his conduct had become undeniable. The record reflects administrative judgment, not any sort of personal attack or any sort of heckler's veto. The governing precedent from Pickering through Heim makes clear, when an employee's speech, rooted in personal grievance, inflicts serious institutional harm, the balance in the Pickering case tips toward the employer. For these reasons, we would like to respectfully request that this court affirm the Court of Appeals and uphold Olympus State University's decision. Thank you, Your Honors.
Thank you. Rebuttal?
Your Honors, the opposing counsel brings in the case of Ballard, but that cannot apply here as that ruling is based off, not based off sex, but rather fiscal and policy means. Furthermore, the opposing counsel brings in the case of Feeney, but this further cannot apply as this regards veterans versus non-veterans, not any sort of protected classification of persons. Furthermore, the opposing counsel brings in the case of Frontier v. Richardson, but this case is more so to show and demonstrate that cases of strict scrutiny can apply in cases of gender discrimination, as it had in Frontier v. Richardson. Although the later courts did favor intermediate, it shows that it still can be held in cases of gender discrimination. Furthermore, the opposing counsel talks about how Denolf was not qualified, but Denolf had proven himself to be qualified through 5 years of experience through state troopers and was beloved on campus by both male and female students alike. There were other also top law school or top graduate schools that produce top quality female candidates rather than this school. It was not the only option. Thank you, Your Honors.
Thank you. Counsel, rebuttal?
Your Honors. My co-counsel makes a great point, that his contract was not renewed. That is correct. However, he was approached by his department head in the spring of 2023 that his contract would not end with the rest of the part-timers. It would be renewed if he agreed to teach a specific class, which he did. And because of that, it was his reasonable understanding that he had a job that following term. And when they terminated with him without any conversation, a meeting, he was terminated specifically by one of his colleagues who he was friends with and worked with closely. It was almost retaliatory in nature. Further, he simply is a blessing to society because he is willing to do what other individuals are not. And that is going against the grain and speaking out about an issue that not others can clearly understand. But because of his uniqueness to academia and the classes he taught, he had an understanding and he felt it was his duty to be able to explain to the public. He once said in one of his speeches, "Imagine true equality, a world fair for all." This doesn't sound like a man talking about himself. This sounds like a man talking about his students and those that he cares about and people who will come after him and what they may suffer under such a harsh law. He did have frustration, but he was frustrated in unfairness. He was not frustrated with specifically the policy. He was frustrated with the overarching issue of affirmative action. And he felt that because it impacted him and he got to see firsthand how it felt and how it impacted his life, that it was his job to go above and beyond and speak out on this issue. Thank you.
Thank you. Council, thank you very much. We will take the matter under advisement, issue a written opinion.
All rise. And I think we can give these guys a hand. The judges will now deliberate probably for about 15 minutes or so, and they will then, after that time, present the results of the deliberation for the winner of this competition, as well as the results from the written legal brief competition. So if you want to stick around for a bit, please do so. There's some snacks. You can help yourselves, and you can find out who the winners are, and support your colleagues. Gary, if you're somewhere, we should do some pictures at some point too. So maybe let them rest for a second and then call them for pictures in a few minutes. Great job. Great job.
That was so much fun.
Thank you.
It is. I would have.
Yeah, I was over time. You did so well.
Thank you. I fumbled a bit in the beginning, but that's okay.
Great job.
I was expecting less.
That was tough. Yes.
You know what I mean? Like that was
expecting. Like, yeah, no, that's fair. Like, I think here it's a lot more they'll let you present your argument.
That's why.
That's what you thought going in, right?
I'm not gonna say anything until the results come out. I wasn't paying too much attention.
Well, if you're doing this, you're welcome to stand here, but the libels don't go.
Oh!
That's so awkward.
Oh, wow. Yeah.
Hello!
Until after we announce the.
Hey, kid.
Hey!
That's appreciated.
So
That's
iconic.
what.
Wait, that's so iconic.
Wait, that's good. That's. Oh, oops.
Not alive. We're just like honestly standing right there in front of me.
No, literally, I feel like my face was like this.
You said
You can. I love you, but you can't. I don't have like a. No. Hi, Mom. Are you doing something?
It's something it's what she did that made the news. But you can certainly without that, you can also just get rid of it. But it can be mainly about this.
Stay right down the street.
I told him, Mason, in this one, there's food. And they locked in. There you go. I was there for
I texted Mason last year, I guess. I told her. Some of those artists last year. Yeah. Let's like add some. It's like the argument.
I just can't wait for that's where my strengths are. When I did the plot, was it's like a holy hell. You wanted to go. Yeah. Did you guys have No. That's a lot.
Oh my god. All right.
All right, everyone, the judges are ready. Go ahead and have your seats again. Yes.
Sit down, sit up. Oh, I have to sit?
Stand. Everyone stands and get to your seat.
Sorry. I get something.
All rise, the Chief Justice and the Associate Justice of the Supreme Court of the United States. Yeah.
Thank you, DC. Let me first say I appreciate having the opportunity to do this, and the other judges and I were all very impressed with each and every one of you. We thought each and every one of you articulated your case well, and that you made your points, and we understood what your points were, which was a good thing, and we understood them enough that we were able to ask questions of you, so we appreciate that. But ultimately, there has to be somebody that we choose as the winner, and in this scenario, we have chosen Mr. Wellman as the advocate that would be our selection.
I was impressed that you, the command of the cases, and you articulated the plaintiff and the defendant's names. You had them write it you didn't have to fumble over this. You memorized them, you knew what the cases stood for. I was very impressed with your command of the cases.
I will email each of you some feedback. There was a lot of good things that should be celebrated and some things for you to keep in mind as you pursue future work in this area, and I think you all should do that. Thanks for your great work tonight. One thing I'll give publicly is that I thought it was great to see your minds at work and anticipating what questions might be asked of you. There were several instances in which you had that answer ready, and that was really impressive, so thank you.
Good job, everybody. Thank you.
Associate Justice Campagna will announce the winners of our written competition.
It is with great pleasure that we announce the winners of the Legal Brief Writing Competition. Students were able to choose this year whether they wish to compete in this Legal Brief competition, the oral arguments competition we just heard, or both. For the writing competition, individuals were asked to write a legal brief supporting the position of either the petitioner, William Denolf, or the respondent, Olympus State University. They were judged on their ability to identify and discuss the major constitutional questions, create a legal argument defending their position that is based on legal reasoning, precedent, and established norms, and apply and interpret the relevant facts in support of their arguments. The top briefs effectively address counter-arguments, exhibit creative and original thought, and demonstrate effective legal writing skills. Our winners this year include first place, Emily Leshin. Second place, Cameron Shook, who I believe I saw here tonight. And third place, Peyton Crims, who I don't think was here tonight. But yay, Peyton as well. Congratulations to our winners and to all of our participants.
So I will just say a few final closing remarks. Thank you everyone for taking the time to be with us this evening, first of all. Definitely, if you want to keep sticking around and congratulate the contestants, please do. I'd actually like the judges to stick around for a moment, and we'll do some photos as well before everyone leaves, if that's all right. Thank you to our three judges, especially Chief Justice Faber, for coming and spending your time with us this evening, and giving our students a chance to really hear some tough questions, which was fantastic, and supporting them as they participate in this wonderful tradition we have here at Monmouth College. So we are adjourned. So yeah, if all the participants could come up here.